Why is the federal government suddenly giving itself the power to place veterans under guardianship and potentially force them into inpatient mental health treatment? Because that is exactly what a new policy from the U.S. Department of Veterans Affairs would allow. And as a veteran myself, I think that deserves serious conversation. Hi, I'm Nate Charles, and welcome back to the Rule of Law Brief. For those of you who don't know me, I'm a former U.S. Navy SEAL officer, a former federal prosecutor in the U.S. Department of Justice's National Security Division, and I'm the founder and managing partner of Charles International Law, where we work on a lot of civil liberties and immigration issues. I've spent a good part of my career inside the national security apparatus of the United States, and I am a combat veteran. So when the federal government creates new authorities that allow it to restrict people's liberty, I pay attention. Now, this new policy is actually pretty straightforward. The VA is working with the U.S. Department of Justice to deputize VA attorneys as special assistant U.S. attorneys. In so doing, they would give them the authority to initiate guardianship or conservatorship proceedings in state courts for certain veterans. The stated goal is to help vulnerable veterans, particularly veterans experiencing homelessness, to transition from hospital care into other forms of treatment. And on its face, that goal is not unreasonable. There are veterans who genuinely need help. But guardianship proceedings are not a minor administrative step. They are serious legal actions which result in a court declaring someone incapable of managing their own affairs. These proceedings are life-changing. Conservatorships and guardianships can lead to outcomes such as forced mental health treatment, involuntary institutionalization, and the loss of personal decision-making authority. In other words, these are mechanisms that allow the state to significantly restrict a person's liberty. And whenever the government expands its authority to do that, we need to pay close attention. Now, let me be clear about something. There are circumstances where guardianships or civil commitments may be appropriate. I have personally litigated these kinds of cases. If someone is truly incapable of caring for themselves, the law has long recognized mechanisms to protect them. But systems that allow the government to deprive people of their liberty based on determinations about mental competence require extremely strong safeguards. Because history tells us something important. Systems like this can be misused. And in this particular instance, there is cause to believe that they will be misused. Throughout history, governments have sometimes labeled political opponents as mentally unstable or socially dangerous. Not because those individuals were actually mentally ill, but because it made them easier to remove them from public life. That pattern has appeared in many different countries and political systems, and it's one reason liberal democracies have traditionally placed strict procedural protections around civil commitment and guardianships. When the government acquires the power to declare people mentally unfit, that power must be handled very carefully. And the fact that these policies are being directed specifically at veterans raises the level of concern even further. Historically, the segment of any given society most likely to challenge a government when it loses legitimacy is its veteran population. And there are good reasons for that. Veterans are deeply invested in the country's institutions. They literally put their blood, sweat, and tears into defending them. But veterans also possess training, experience, and leadership skills necessary to foment and mount a successful military resistance. In other words, veterans are uniquely capable of organizing and speaking out when they believe those institutions that they defended are starting to fail. So when the government creates mechanisms that allow it to declare veterans mentally incompetent and place them under guardianship or involuntary treatment, we need to be very cautious. These policies could be abused by the Trump administration to suppress dissent and undermine insurrection. And I take this possibility especially serious because of things that have happened in my own life. Let me be candid. I have personally experienced something that I can only describe as judicial gaslighting. Essentially, an agent of the government falsely accusing me of having mental health issues in order to deprive me of serious liberty interests. A few years ago, I had a very messy divorce. And in the custody proceedings, a court-appointed mental health evaluator concluded that I was a fit parent. And frankly, so was my ex-wife. She concluded that neither of us had significant mental health issues affecting our ability to parent. But despite that professional assessment by a licensed therapist, the judge in the case held that I was unfit to be a parent by falsely claiming that I had mental health issues and used that as justification to severely restrict my parental rights. To be clear, there's quite a bit of evidence suggesting that that judge's decision was retaliatory. The judge only allowed my mental health to be questioned after I had raised questions about the judge's competence in certain areas of the law, including issues related to veterans benefits. Despite the fact that I had asked that judge to recuse herself, the judge refused to do so, disregarded the custody evaluator's findings, and instead relied on a false narrative about my mental health that was not supported by any mental health professional. Now, my point in retelling this story is not to relitigate that case. I'm doing that elsewhere. But it is to explain why I pay very close attention when any governmental organization creates systems that allow people to be labeled mentally unfit in the absence of very strong evidence. Once a system begins to treat someone as unstable or irrational, that label can become incredibly powerful. And in my case, the narrative becomes a convenient excuse to do something that the government wants to do, even though there wasn't any evidence to support it. I've experienced this firsthand. And that experience is one of the reasons I take the possibility of government systems misusing mental fitness determinations very seriously, especially when those systems create tools that could potentially be turned against dissent and meaningful resistance to authoritarianism. Veterans fought to defend the Constitution against all enemies, foreign and domestic. And any system that gives the government greater power to take away their liberty should be examined very carefully. Not because we are opposed to helping legitimately vulnerable veterans, but because protecting civil liberties is part of what our veterans fought for in the first place. And we should never forget that.